I'm Katie Clunan, and I'm here today with Karen Oakman. We're partners at Clunan and Oakman Law. Karen handles criminal defense matters as well as family law matters. Karen, recently I had a client that had a domestic violence issue with her husband. The police were called, they took a report, and she filed for an emergency restraining order. Well, it turns out the DA is going to drop the charges, and she was concerned on whether or not she could move forward with that restraining order. How would you explain this to my client or other viewers that have questions about the different standards in our courts?
So we use different, what we call standards of proof in our criminal justice system and in our court system. For the DAs to prove at trial that somebody's guilty of a crime, they have to prove it beyond a reasonable doubt. That's probably a term that everybody has heard. Mm-hmm. It is the highest standard in our system. For domestic violence restraining orders, we have a lower standard due to our state's desire to protect victims of domestic violence. It is preponderance of the evidence, which is just more likely than not. So yes, there could be times where a district attorney doesn't believe they can prove a case beyond a reasonable doubt, but there is enough evidence to issue a domestic violence restraining order. And so those may still proceed forward.
Great. Thank you for explaining that. I know my client had questions about that. If you have any questions or are interested in learning more about restraining orders, please reach out to Karen and I. You can find us on Facebook and on our website, clunanandoakmanlaw.com.